Today's session, we're going to run is on staff books, staff handbooks and policies. This is the last session I think was quite a hard going one. So this one's I think slightly less intense, I hope anyway. But what I will obviously do, Natasha has the slides, and obviously you will get all these at the end. But if anyone has any questions as we go along, please just raise hands and happy to take them, or we can have a bit of time at the end. I don't think this is maybe quite as long a session as the first two, just in terms of the material we've got. So hopefully we should have plenty of time to take questions if anybody has any. So if we could go on to the first slide, Natasha, please. Thank you. Yes, what is a staff handbook? Now, I think in my whole time of working in the law department of the Church of Scotland, I've only once ever been asked by a congregation to review their handbook, which for some of you might, I must be honest, I was equally surprised that someone had been so diligent as to prepare a congregational staff handbook, but it does happen. I mean, effectively, staff handbooks are largely aimed at sort of great larger organisations, like Royal Bank of Scotland or Sainsbury's or something like that. I mean, I think it probably goes above and beyond perhaps you guys as congregations to necessarily have your own staff handbooks. But basically, I mean, obviously, if you want to put a couple of things in a handbook, that's good. But I mean, handbooks are basically company guidelines on what an employee needs to do in various situations. What is probably more beneficial than necessarily having a full handbook of everything is probably to sort of develop staff policies on various matters, and that's obviously what we're going to go on to have a look at next. So if we could go to the next slide, Natasha, thanks. So yeah, it says here, what should be included in an employee or staff handbook? Now I've listed sort of examples here. The next slide covers some more. I'll go through a couple of them just kind of now, though, that might be relevant. The way this is prepared is obviously I could be sort of saying what's in the handbook for a large organisation or yourselves, but things that probably are worth having are health and safety policy. Obviously, it's probably out of those ones important. Data protection policy as well is also important, although I think, and maybe you guys will be able to correct me if I'm wrong, I think if you have data protection queries, we obviously have a data protection officer centrally who I think you would probably refer matters to, and I think maybe presbyteries will have their own sort of data protection resources in place. So it might not be that, it may well be if you ever feel that there's been a data breach or anything like that, that rather than have to have your own policies, you could refer those centrally. But certainly health and safety guidelines, very much something that obviously if you are within your own congregational buildings, church, outhouses or whatever, you might want to have policies on that, especially if, for instance, you have got workers who potentially, like a cleaner, who might come into the building on our own. For instance, I mean, you wouldn't obviously want the cleaner in maybe on a Sunday when the services are on, and it might well be that the cleaner's hours of work or something between like 7 and 9 in the morning before anyone else is in. So it might be handy to have kind of at least, whether even if it's not a full health and safety policy, certainly health and safety guidelines for employees who may be working on their own, etc., etc. The next slide, if I could please, Natasha. Here's just more examples of what you might want policies on. I should say, if anyone specifically has a burning need for a policy, if you've come across an issue, I can happily help you prepare one. We do have access to all of these. And if you have used Church of Scotland's style template contracts, which I think, to be fair, more and more people are now doing, in as much as it's makes your lives easier than having to draft them from scratch. Things like sickness policy, disciplinary capability and dismissal, and grievance will be covered in those contracts. Those of you who've maybe looked at the style contracts recently will know that the style templates that I and my co-workers in the law department have produced, there's obviously the contract, then Schedule 1 is dedicated to what the duties of the role are. Schedule 2 covers it's a generic disciplinary ground that we've sort of set out, which if you use our template contract, you would follow. And then the third schedule is the grievance procedure. Issues such as harassment, whistleblowing, and redundancies, they are probably less, I suppose. I mean, they're all in themselves fairly serious, but probably, I would have thought on a day-to-day basis, you're not going to necessarily in a congregational setting have too many whistleblowing claims. But obviously, if anything like that were to come your way, you can obviously refer that to us in the law department, and we can obviously provide you with some guidance on that. Redundancies, alas, are all too commonplace within congregations at the moment, especially with those that are going into a union, or simply there being a shortage of funds, meaning that it's not sustainable to necessarily pay someone to do the role, and it might well be that the role needs to be filled by church volunteers or session members or something like that. So redundancies is an issue. I think if you're ever in a situation where you are faced with a redundancy, and I know most of you on this call would, come and speak to us about it. Redundancies, whether you're doing a redundancy for a massive organisation or you've got 2 employees within a congregation, there is a set procedure in law you need to follow. And I think certainly, and I don't think anyone in this particular call is an example of this. Certainly, I've had people who have contacted me looking for some advice about a redundancy situation, and were, obviously didn't have an HR and employment law background. They were quite surprised that, with only having 1 or 2 employees, or maybe, 4 or 5 at the very most, that they would have to follow such a strict process in dealing with a redundancy. But the redundancy, the procedure for redundancy is actually one that's set by law. So as I say, whether you have 1,000 employees or 10 employees, the steps that you need to do for a redundancy are effectively the same. So if you're ever staring with a redundancy situation down the eye, please get in touch. I have got a lot of I just so happens, and it may well be, there's one other person in my team who gives advice on employment matters. But I think certainly I probably do the bulk of it, and I've given a lot of advice about redundancies this year to congregations across the board. So if you do have a redundancy situation on the cards, or you think you're going to face one, I have got a pile of styles, templates, and various things I can give you to help you with that. So please do let me know. If we could maybe look at the next slide, please, Natasha. Thank you. Equal opportunities. I've put this in because this is a very equality, diversity, inclusion is a very, very trendy area at the moment of employment law. I think, in fact, centrally, and it may well be it's been rolled out to you guys too. I don't know, or it might well be, but certainly our central HR are running equality, diversity, and inclusion training. For us all to go on, and effectively it is sort of setting boundaries for employees as to what is acceptable and unacceptable behaviour in workplaces. And I think it'd be fair to say, for those of us like me who are slightly more long in the tooth, I mean, I can say it certainly. I've been now working for, I think in fact this is 25 years this year, and certainly things have changed considerably as to what was acceptable in a workplace 25 years ago as to what is acceptable now, the language you can use, the way you can behave. These things are all things that were acceptable, or things you could say, or things, it's all very different now. And there is no doubt that a higher level of being PC is definitely expected within the workplace. And if we don't follow those guidelines, there's a risk that potentially we might face a claim. So an equal opportunities policy, I've prepared this sort of more to kind of give you steps rather than I'm expecting you all to come off this call and draft an equal opportunities policy, but it's maybe just things to sort of bear in mind if you're kind of dealing with congregational HR. Obviously, things like confidentiality, I'm sure you all respect that, and clearly in any kind of employee situation, that's very important. Complaints procedure, hopefully there won't be too many complaints you'll need to deal with, but obviously having some established complaints procedure is helpful. Certainly if you ever are faced with a complaint that you think potentially has got some merit to it, or something you think is quite serious and could go somewhere, then obviously please come and speak to me about that. Complaints at congregation level, I often find, I think there's quite a lot of crossover with the safeguarding team. I think with a lot of the complaints you sort of get, I mean, it will usually be instances of I mean, perhaps something inappropriate has been said, or something inappropriate has been done, not necessarily always bad, but it's caused concerns anyway. So that I tend to find more and more that if I'm dealing with congregational complaints on a day-to-day basis, I'm quite often liaising with my safeguarding colleagues in one-to-one about those as well, just to make sure that we're dealing with a complaint, and the issues go hand in hand with those. So the next slide, please, Natasha. Thanks. This is probably worth a little bit of time. I mean, I've obviously talked about having policies in place. I mean, a policy suggests that there is perhaps a 3 or 4 page document that goes into copious detail setting out various things that need to be done. But I think if you probably take away anything from, or one of the takeaways to definitely take away from today's session, is think about your health and safety. Obviously, there is support at congregational level. I think through Natasha, actually, in fact, is probably your contact on that. Obviously, centrally as well. We obviously have health and safety at 121 who can advise you, and that goes to sort of general trustees as well. Obviously, have a health and safety officer as well, so we're pretty well stocked on that. But from your perspective as employers, things to obviously think about in the terms of health and safety, I've listed a couple of these there. So manual handling, obviously, I would have thought, and it's worth doing. Some congregations still do have kind of people who they might call handymen, or sort of odd jobs people that kind of maybe do stuff. I suppose as well, it's not uncommon, possibly even in the scheme of volunteers who are moving church benches or something, or possibly the sort of maybe slightly elderly age of the people doing the lifting as well is something to bear in mind with these things, and it's certainly worth making sure something like that is covered as well. The next slide, if I could possibly see that, Natasha, please. Yes, obviously we do have the situation where people do have accidents at work. Hopefully it's not too frequent an occurrence, but certainly have a procedure for recording accidents in place. I think as well, and I think it's something that I am aware of, but maybe don't know so much on the ground. But you'll no doubt obviously have a relationship with the Church of Scotland's insurance services the team as well. So if you're ever a situation where there is an accident at work, or somebody has got an injury, clearly let the insurers know as quickly as you can, even if nothing comes of it. I mean, it might even be if a congregation member has a slips or injures himself in the bathroom or something like that, whilst it might well be they'll say, oh, I'm fine, it's nothing. It's always worth noting it down, and if there's any kind of potential injury, keeping a note of it just in case something comes of it. It was maybe in the summer of this year, actually. I had a really difficult situation with a congregation in south, just a little bit further south of Edinburgh, where there had been an accident in a congregation. A child there had been a fire door in a church, and I think the door had slammed shut, and the child had actually got quite a bad. I mean, it sounds a lot worse than it probably sounds a lot worse than it actually I think was, but I think they sort of lost a bit of the top of their finger in the incident, and because this congregation didn't really have sort of the armoury in place to deal with it. I mean, they obviously noted it, dealt with it. I think at the time the child and her mother had said they were okay, but subsequently, as is the world these days, the took some legal advice and pursued a claim, and I mean, I think it was one that was eventually dealt with through the Church of Scotland's insurance services, and all was good. But it was that type of thing where I think the congregation's learning point very much is, well, if we'd had a system and taken notes, maybe taken a witness statement or done something, just kept records and everything else as well, this would have been much easier, because obviously you're not going to get a letter of claim in from one of these ambulance chasing litigation firms for a few months, and you'll find that the incident will happen in June, and then come September, October, you'll have forgotten about it, and then at the end of that month in pops this letter saying, Joe Bloggs had this injury, and they're seeking damages for it. So I mean, good paper trails for these things are always very helpful, and you obviously do have the benefit of the insurance support through the Church of Scotland insurance services as well. So please do use that as and when necessary. And obviously as well, that inevitably health and safety, accidents at work, etc., crosses over with the legal aspects, and as well as dealing with employment work, I deal with health and safety and accidents at work as well. So you can come to me, again, happy to give you advice in relation to that. Sometimes I know the few times congregations have been in touch following an accident, often or not. I mean, it's if you've ever been involved in an incident yourself or a road traffic accident, sometimes there's an element of shock post-accident or post-incident shock, and actually you might well be a very rational, very sensible person, but actually when you are in the throes of it, you're maybe not in your best form in terms of dealing with things. So it's at that point it's maybe good just to sort of, it's good to talk, speak to me or somebody, and we can hopefully reassure you and just calm you down a bit as well, because it's these things can on occasions be unpleasant. The last point I have made is health and safety representatives. Now that's obviously aimed at much larger organisations, but it is maybe helpful from the point of view of a session to have somebody who is maybe, I mean, it might well be there'd be a little group, but if the session were minded to have, you know, a couple of individuals who would sort of, you know, focus on health and safety aspects, and that was something, I mean, that was something to be willing to do, that is a good idea. I know congregations do tend to have, you know, if they're not sessions have got members who kind of deal with you know, finance, business, property. You'll have a couple who deal with that, but one that I think is sometimes overlooked in sessions is someone who sort of takes a rein on health and safety. And I mean, you know, what we're not expecting in doing that is for them to be in any way experts, but simply maybe that they can take responsibility and liaise with someone like Natasha, or liaise with somebody down in central services. It's just congregations, I think, are very good at dealing with finance. They're very good at dealing with the property, business, etc. But sometimes health and safety is an overlooked issue, and if there is certainly scope to maybe have someone within your session just keep an interest or a toe involved in that, that is, I think, always very good practice as well. So the next slide, I'm going to whiz through this one because I think it would be, I'm not anticipating it's going to be a huge issue for many of you. Although, funnily enough, I have had to give advice to a congregation who had a cleaner who did unfortunately keep turning up to work under the influence, and it was all very unpleasant for them and her. But I mean, I think whether you need a policy or not is another level. But I think it's handy to have the notes in it as well. Suffice to say, obviously, if an employee is engaging in drugs and alcohol at work, there might well be exceptional circumstances for the use of such things. And obviously, if there is Christmas party or possibly something, you know, there could be differences, but largely drug and alcohol use at work is prohibited, and certainly in most circumstances it would fall within the remit of being gross misconduct, which would likely render dismissal an option for the employee. I know certainly some congregations have had employees who have been going through possibly very difficult times. This example that I had of this poor cleaner, I think she'd maybe lost her husband to cancer or something. There had been, I think she possibly turned up at work a little bit worse for wears, and on maybe that occasion she was a little bit of grace was extended to her, although she was obviously informed, you know, this, you know, well, we can let it go on this one occasion, but clearly, you know, if you know, we would expect you to come to work, able to work, and it might be a sort of case-by-case analysis and basis as well for that. So something just to bear in mind. I mean, obviously, it would be slightly different if we had congregations who had a lot of staff members who were out doing driving jobs or whatever. I mean, you know, companies like sort of Amazon and DPD and things would obviously, people who do all our online deliveries and stuff will have very strict drug and alcohol policies. In terms of the employees that you guys will have, it's probably less of a problem, but something to just bear in mind anyway. I mean, you know, if employees are turning up to work, and I suppose maybe this time of year is the time when that is maybe more likely than not, under the influence of any substances. Clearly it is an employment matter, and it doesn't. I mean, on occasion, a word can be had and possibly a blind eye turned, but largely, we would be looking at taking stringent action if that happens. If we could look at the next policy, please. Next slide. This is on staff emails and internet policies. So a lot of this sort of crosses with data protection use as well. The message generally for certainly for ministers, as far as I'm aware, is that you should be using your Church of Scotland email addresses for business work. I'm sure probably in some guys everyone's been told that, but that I think certainly is the line. I understand business, use your business email for business purposes. Confidential information as well. Clearly, that if we are, it will say in the contract of employment that people sign that you're obviously going to come into. You're going to obviously, as part of your role, be aware of confidential information, but that shouldn't be disclosed, which is important as well. Staff internet use. This again in sort of larger organisations can be a problem. People abuse the internet policy and use it for social purposes, and going on Facebook and Twitter and X and all these various other things. And obviously that what you do at your lunchtime probably is provided you're allowed to is reasonable, but certainly you shouldn't be going on these websites during your working hours. Also, another point as well, certainly on sort of staff email, staff internet, and I attended a seminar very recently, employment related, about most of us probably have some form of social media or LinkedIn account. Very important that we do not discredit our employers in those. For instance, if you maybe use this media platform LinkedIn, which I think quite a lot of us do link in. I link in. I sometimes think it's quite interesting, sort of professionally, just to see what's going on. But certainly in my LinkedIn profile, I shouldn't be saying anything that or making comments about the Church of Scotland that would bring the organisation, charity, into disrepute. So certainly, if you find that if employees or anyone are using personal accounts or emails to make comments about the congregation or the minister or anything like those lines, or staff members, I mean, certainly that can be a disciplinary matter if it's out there. The fact that they're doing it in their own time, the fact that they are, even if you don't say in your account that you work for this employer, it could simply be the case. I mean, if I just had my own personal name and I didn't have anywhere on the account that I worked for the church, but I made a derogatory comment about the church, doesn't matter, because my name is obviously associated with the church and I've made the comment, the employer can still rely on that. So it's not a mitigating excuse to say, oh well, I didn't say my employer was this congregation, or I didn't say my employer was the Church of Scotland. The fact that the employer has found this, it's available on public domain, and it's making critical comments in itself can lead to action requiring to be taken. Next slide, thank you, Natasha. Data protection. As I've said here, it's a legal requirement to have arrangements in place to ensure safe storage and processing of data about employees. This, I'm sure, is quite heavily regulated by Presbytery and those of us at 121, but it's just to be aware of it, obviously. With data protection, data breaches do occur. It's quite easy. I mean, a data breach can be as simple as you type in the wrong email address, you send over an attachment of something that this person shouldn't get. That effectively is a data breach. I mean, the thing to do with a data breach, or to advise staff members is simply deal with it quickly. If you make them, I mean, I have over the years. I've been doing this job not terribly often, but I have on occasion sent an email. If for instance, I was sending the email to, for instance, Natasha Hepburn at, outlook.com, and it should have been natasha.hepburn@outlook.com, for example, and you've sent it to another Natasha Hepburn, who is not the Natasha Hepburn I was wanting to send it to, but who lives in Australia or some other place in the world. It does happen. And it's, these are errors, but simply let Presbytery data protection or Alice O'Sullivan, our data protection officer, at 121 know. What we do is we record that with what the data breach is. There's a form that you require to fill out, and a note of that is kept. And usually, in very minor circumstances, nothing further will come of it. And I mean, you can sort of sit back and think, well, I've done the right thing. Obviously, there can be more serious data breaches, and I've been involved in a couple where sort of dates of birth and documents involving sort of younger. I mean, it'd be possibly if you've got younger members of a congregation or something, and there is a data leak with that potentially might be slightly more serious if the data gets into the wrong hands. But again, the advice is exactly the same. You've got a duty to report it, so the sooner you do that, steps can be taken to address any issues that might have arisen. Have a look at the next slide is maternity and paternity leave. This does arise not infrequently as a sort of employee issue and what you need to do about it. The likelihood is that you will not have maternity or paternity policies in place. I wouldn't have thought that very likely. I mean, certainly if you do have an employee who is asking for maternity and paternity leave, please speak to me about it. The real thing that you need to make sure you do as the employer is treat staff members the same. So, for instance, if you've got one person who's gone off on maternity leave and they were given sort of X months of full pay, X months of Y months of half pay, or whatever, you follow the same procedure. So, for instance, one person doesn't go off on 3 months full pay, 3 months half pay, and then the other person, for example, is getting 6 months full pay, 6 months half pay. So it's important that we can have a conversation just to check that you're applying a sort of strict and straight procedure across the board. Paternity leave now far more common than it was, obviously, many years ago. The government guidance at the moment on paternity leave, although I think they are looking to change those rules, is that paternity leave is 2 weeks. Paternity leave, you get 2 weeks off. You don't require to take the 2 weeks at the same time, although you're required to take 1 week at a time. And at the moment, the law just says that you simply need to be paid statutory paternity pay, although some employers do have policies in place where you might be given a week of your normal pay and then a week of statutory pay or whatever. I mean, I think there's no real rule on that. It's very much down to the employer what they want to do. The main thing, though, is just to ensure that you have got consistency with what you're doing. So, for instance, if an employee if employee 1 goes off in statutory paternity pay, when employee 2 goes off in statutory paternity pay, assuming the law hasn't changed in that time, there should be similar treatment for both. Yes, so adoption leave, you may or may not come across that, but something just to bear in mind. The chances are, if the employee asks for it, they will have looked into it and maybe know a lot more about you. So just good to have that on your radar, that actually if someone asks for adoption leave, you don't go, well, you can't have that. More, you can, and obviously, feel free, if you're ever faced with that situation, to come and seek some advice about it. I mean, certainly, adoption leave is not something specifically that you would necessarily have a policy on, but parental leave is something that if you've maybe got sort of younger members of staff who are working there, it might be an option. Parental leave was introduced, I think maybe slightly under 10 years ago. And what it effectively does is it allows parents to take time off. For instance, if maybe your child is transitioning from sort of primary school to secondary school, effectively you are away from your work, but it is not annual leave. I think historically employees expected employers to sort of take annual leave for these things. Obviously, if we all had such generous annual leave entitlements, that would be fine. But similarly to carers leave, which we've touched on in the last session, parental leave is leave which would allow you to take time off if your child was maybe having difficulty settling into school or was unwell. Parental leave is something you can do. It depends very much on the employer if you pay people for parental leave or not. I tend to think, and I think certainly central services here, parental leave is not paid. So you are effectively taking a period of unpaid leave from your work. But if someone seeks parental leave, the reality is the employer cannot really refuse it. What they can, for instance, if you wanted to take parental leave between Christmas and New Year, I think the employer could maybe go, well, could you maybe take it at a different time, given everyone that possibly in the world wants that time off. But the employee cannot say to the employer, no, you cannot have parental leave. The only option open to the employer is to negotiate with the employee when times might be suitable about it. But I think you tend to find, certainly in experiences I ever give advice on parental leave, it tends to be if you've got a child, if the parent tends to be wanting time off for a child who is maybe transitioning from sort of schools, or if you've just moved from, if you've maybe moved from like Aberdeen to Glasgow and you don't know the area or whatever, the reasons tend to be fairly reasonable that are given by people wanting it. So in the circumstances, you're more or less able to accommodate it. So flexible working, probably pre-COVID, this was a bit of an anomaly. Now flexible working is fairly standard for most employers, or at least the option of doing it. Flexible working and hybrid working are largely the same. The difference with hybrid working is usually that's something that's set by the employer. So for instance, the employer would say to the employee before they start the role or during the role, we have a hybrid system of working. So you would come in 3 days a week, work 2 from home or something like that. Whereas flexible working tends to be far more specific to the needs of the employee. So for instance, flexible working might be if you work a 35-hour week, but you between say 3 and 4 in the afternoon, you don't work that hour because you need to accommodate picking up your child from school or something. So a flexible working arrangement might be your hours would be 9 till 3, and then you could work 4 till 6 or something like that. So you're effectively doing your contract hours, but accommodation is made in between that to allow for needs. Or for instance, if I have a slightly flexible working arrangement with my work, the days I drop my children off at school, that sometimes it can be 9:15 before I am at my desk, but because it's such a minimal arrangement, I haven't got something so strict in stone about that with my line manager. But certainly if you've got someone who, for instance, wanted to sort of, they couldn't accommodate sort of the classic 9 o'clock start or wanted flexible arrangements, then that's something to bear in mind. Flexible working requests all have to be considered by an employer. So an employee has the right from the first day they join a job to make a flexible working request. If depending on what the request is, you might be very able to accommodate it. I mean, for instance, I suppose if someone says, I can't really work 9 till 5, can I work 10 till 6? It doesn't, on the face of it, doesn't sound particularly unreasonable to me that that would happen. So you could probably grant that. However, if it's something slightly more different, one that you do find happens, slightly more often in settings is, for instance, people want to only work, the people's a flexible working request then to take a half-hour lunch as opposed to an hour lunch, because it means they can finish a half-hour early, and that kind of suits them. And that one, whilst I mean, I think it varies with the employers how they feel about that. I mean, I don't think I really normally ever take a full lunch hour, even though I'm entitled to it. But employers are sometimes reluctant to say to employees, yeah, we'll only give you half an hour lunch, because clearly you are meant to take an hour, for your lunch. You are meant to switch off, have a break from what you're doing, have a break from your screen, or go out for a walk and get some fresh air. So sometimes employees are slightly more reluctant to kind of change that. But I mean, with any flexible working decision, discuss it with the employee who approaches it with you about it. Listen to the reasons they've got. And if you find them persuasive and they seem reasonable on the face of it, then you might be able to agree to it. I mean, there's no obligation to grant a flexible working request. It is at the discretion of the employer. Obviously, though, what you're looking for is to make reasonable decisions. You should give a decision after you've made it. For instance, if an employee said, I don't want to work 9 till 5, I'd rather work 7 in the morning till 3 o'clock in the afternoon. So clearly they're working, I mean, clearly on paper that sounds like they're working the same hours. But for instance, if it's not appropriate for the office or the building to be opened up so early in the morning, or it would mean that, if there's only one key holder, someone senior, and they might not want to give a set of keys to the cleaner or whatever, that would be a reasonable ground to refuse a flexible working request, to say, well, look, we only have one set of keys or whatever. We don't. It's important that there's other people in the building with you or whatever. So, I mean, the employer has got discretion to refuse a flexible working request, but I mean, you should set out a good reason for it, just to avoid any challenge. But I mean, if the flexible working request is refused by the employer, largely there's not much more the employee can do, provided they've actually considered it and they've done so on reasonable grounds. So the next one, the next one is probably a slightly more relevant one for us all: sickness. Sickness, sometimes you are lucky and you get employees who never off sick, or take 2 or 3 days off a year. They're the good ones. Other times, though, you do get employees who, more often or not, sometimes, whether it's to do with mental health issues as well, require a fair amount of time off work. So it's worth having some sort of sickness policy in place. Our template contracts set out sickness policy that we generically suggest you have. So for instance, that would mean you self-certify for 7 days. Thereafter, you would go to your GP if you need longer off and get a fit note. The template contracts we use, again, set out terms and conditions of what your sick pay is. So for instance, for a certain period, you'll get your full pay. Thereafter, you'll move on to half pay. And thereafter, if you remain still off after that, you'll get statutory sick pay. Probably quite clear, and I think, again, the contract does it, that we use just obviously the employee's responsibility. Employees obviously have got a duty to notify their employer that they're not going to be in work. We touched on this a little bit in the last session about, I think I'd mentioned about this kind of texting or WhatsApping in, saying, I'm not coming in today. Clearly, some employees insist that you phone in. Others, an email or something will suffice. It very much depends, but I think it's good to get out of this sort of. I think even though we now are in a world where technology, is all around us and all helpful, in the sense that, I mean, we all do text and WhatsApp. There is something more formal, I think, about, if a person is not going to be attending their work, it's probably a good habit not to get into that they're kind of WhatsApping their boss or just WhatsApping their friend that they work with. An email into their line manager is clearly a far more appropriate method to do that. So I'll move on to the next slide now. Disciplinary capability and dismissal. You may well, in your runnings with employees, have issues involving disciplinary capability and dismissal. By way of definition, disciplinary and capability are two different things. Effectively, the sort of the policies that you use with them can in many ways be the same, but disciplinary is, for example, when you do something wrong. So, for instance, you don't turn up at work, or you are rude to your boss, or you have poor timekeeping, or something like that. Capability, on the other hand, is where you are not performing your role appropriately. So, for instance, you've not done anything wrong, so you've not sworn at your boss, you come into work on time, but basically, capability is where you are paid to do something and you're not performing the role appropriately. So, for instance, if you can find, often or not, that capability issues initially arise informally between a line manager and an employee. For instance, if the line manager says to the employee that when you do this task, you need to do this, or you need to write it down, or you need to make a note of it, you often find that then it becomes a capability issue when, after a few occasions, the employee is not taking it on board and is still not performing the role. As I have said, and for those of you who have obviously ever spoken to me or ever been in touch with the law department regarding disciplinary or capability, ACAS guidelines, employees are far more aware nowadays of their rights, and most people, if they're saying they've got a situation at work or whatever, will, if they're chatting to their friend about it for whatever, most people will now be aware that they've got the benefit of going to ACAS and getting guidance, and ACAS have got policies on how you should deal with disciplinary and dismissal procedures, and certainly before any employee can raise an employment tribunal claim against their employer, they have to go through ACAS and get an ACAS certificate to show that they have at least there's been attempts at employee conciliation before you simply go down the route of raising an employment claim. We could look at the next slide, please, Natasha. Thank you. So, yeah, disciplinary capability and dismissal. This is kind of dealing with capability procedures. So, a capability procedure would be, for instance, where, you might find, if you've got someone who does an administrative role, that they keep making the same mistake all the time, over and over again, and you've spoken to them about it, and things are not improving. You might want to put them on a capability procedure. Effectively, what that involves is the line manager meeting with the employee, setting them some objectives for improvement. So, for instance, if you're not doing something properly, you'll say, right, well, for the next 4 weeks, every Friday we're going to meet, and I'd like you to show me the work you're doing, just so we can monitor it, keep an eye on it, and work towards improvement. Capability is largely, whilst many employees who are subject to capability do think it is punitive, in certainly the law, the purpose of it in law is certainly meant to be, it's supposed to improve the employee's performance. So if you have got an employee who's got a number of deadlines a week and they never make their deadlines, the capability procedure is obviously supposed to assist them in being able to make their deadlines and help them. If you go through a capability procedure and the employee's performance of their job doesn't improve, that would enable you to then take disciplinary action against them and subsequently end the employment depending upon what the issues actually were. With disciplinaries, there's obviously a number of levels to those, and if you ever are faced with a disciplinary situation, you need to look at it and kind of see what you think it obviously is. Our template contracts do give you examples of what would fall into the category of gross misconduct. Gross misconduct is obviously the most serious, because gross misconduct, if the conduct that forms the disciplinary falls into the category of being gross misconduct, what that can result in is your dismissal from your employment. If obviously it is not gross misconduct, then the likelihood is that will result in a less serious sanction being given to you. For instance, I have suggested here a disciplinary warning, or you can have a written warning or something along those lines as well. Disciplinary, those of you that have ever had to do it, never a desperately pleasant matter having to discipline or take someone through disciplinary. Inevitably, the person who is subject to the disciplinary, unless it is a clear as day disciplinary offence, will likely challenge you on it. And that can be unpleasant and difficult for the person leading it. If you are on the brink or think you're going to face a difficult disciplinary, please come and speak to me about it. I'm happy to kind of script you and guide you through the process as to what you should do. First and foremost, if you're doing a disciplinary, I would always advise you to have two people there where you're doing it. One person would obviously be sort of essentially leading the disciplinary and conducting it, and you would have another person there as a kind of note taker. And I mean, obviously the note taker can get involved and ask questions as well, but I mean, effectively they are there as a second pair of eyes, just to make sure that that if the disciplinary hearing happens and the employee is dismissed or some kind of disciplinary sanction is applied to them, subsequently down the line, the employee does not say, well, that's not fair, this didn't happen, or whatever, that's why you'd always want a second person there as well. Depending on what the potential disciplinary offence is, it might be necessary for you as an employer to instruct an investigation into the disciplinary offence. What that involves is gathering evidence, speaking to people, obtaining something like CCTV, for instance, is also something you can do, basically gathering evidence to support your case. And what you would therefore do is, after your investigation is fully complete, you could decide whether you're wanting to take disciplinary action against the employee. Gross misconduct, yep, I obviously touched on that. That's the most serious, and that is, for instance, where you commit a serious offence. That could be something like a criminal offence, if you've theft or something serious like that. Possibly also a very serious safeguarding breach could be gross misconduct. Stealing, insubordination. There's quite a general cover under gross misconduct for the employee's loss of trust and confidence in you as an employee. That gives you quite a wide umbrella to do that. Generally speaking, with disciplinary and capability and dismissal procedures, the law is very much on the employer's side in these matters. The important thing when you are ever dealing with these matters, and again, it's obviously, this is where it might be important to come and speak to me about them, or another member of the law department, is obviously make sure that what the employment tribunal would be looking at if you ever have this type of cases, not really, it's not the decisions that you reached, it's much more the processes that you followed to reach them. So at the end of the day, you know, a situation could arise where an employee or an employer dismisses an employee for some disciplinary matter. Perhaps in the employment judge's head, he might think, that sounds a little bit harsh, but that's not the job of the employment judge. The employment judge doesn't put himself in your shoes. What he does is he looks at the processes and the procedures as an employer you followed and determines whether they are fair. And in light of those fair processes, did you reach a decision that a reasonable person could have reached? And more often than not, the answer to that will be yes. You can, you know, there is a well-known case of, I think it was in a car, one of these kind of car showroom places. So it was a fairly sort of lads kind of work environment where a younger employee used a lot of profanities to describe his boss to his face. They followed a fair procedure. He was dismissed. Now, I mean, whilst swearing is never great, clearly, on the grand scheme of things that you could be dismissed for, you could have been having a bad day or whatever. And I think, in fact, that was what the employee tried to argue, that normally he was very level-headed, didn't normally get upset about things, but on this occasion he simply lost the plot and said these things, and it was not fair. His employer dismissed him summarily for gross misconduct. But the employment tribunal found in favour of the employer. The main reason was because they'd followed a fair procedure, they'd had an investigation, they'd looked at it, they'd heard the sides of the events. So you are in most matters, provided you follow fair procedures, you follow due process, you are very unlikely going to find that an employee, that the tribunal is going to find against you for these procedures. Another important point as well, and again, I would always guide you on that, is you would allow your employee the right of appeal of any decision. So, for instance, if the employee is subject to any sanction, they should be allowed the opportunity to appeal the decision, especially for one that might well be a dismissal, in case they want to do that. So again, it's all following procedures and processes, as the employer will largely keep you in the right. So other point to cover here is grievances. As I'd mentioned earlier on, grievances are covered in Schedule 3 of our template contracts of employment. And grievances are where the employee has an issue about something at work. So it could be a grievance about, if they feel that their line manager is not treating them properly, or that's one that the person they work with gets a better deal or whatever from another. Often or not, you tend to find that grievances relate to the employee having an issue with the person who supervises them or line manages them. That tends to be the more kind of standard grievance that you are likely to face. Again, I would always recommend, as I've said in the slide, that you follow ACAS grievance procedure on that. The grievance procedure that we follow in our template effectively is that the grievance is investigated, and a decision is communicated to the employee in writing if the grievance is upheld, and obviously explanations are offered as if the grievance is not upheld as to why that is not the case. if you do face an employee grievance, please come and speak to me about it. Again, I'm more than happy to kind of guide you step by step through the process. And again, it's important as far as appeals go that the employee does have a right of appeal. So, for instance, if the employee is saying that their line manager treats them unfairly or bullies them or harasses them or something like that, the workplace investigates it and says, no, we don't uphold that. It might well be the employee is very aggrieved at that, but they should be given the right to appeal the decision if need be. So the next slide touching this one, hopefully not something they're going to have to deal with hugely, but it is something that does arise in workplaces a lot more now, is harassment in the workplace. And basically, I've kind of set out here in quite a large definition, which is something for you probably more take away. But harassment in the workplace is something that must not be tolerated in any shape or form. And I suppose that stems largely from perhaps what is now sort of hopefully confined to the history books of male employees possibly passing comments about female members of staff or such situations like that, or making inappropriate comments about the way a female member of staff looks or something like that. I mean, unfortunately, it does still happen in certain work environments that are possibly slightly more male dominated or whatever, but clearly it's not permitted. And if we are aware of any issues of harassment or bullying such as that, then we need to deal with them. If harassment, if depending very much on what the issue of harassment is, it would be a disciplinary offence, and I suspect that if it was very serious, it would likely result in gross misconduct. If an employee is saying to you that they're being harassed at work, or there's an issue of harassment at work, obviously come and seek some guidance from us on that. I mean, at the end of the day, a harassment matter would be dealt with in the same way as a disciplinary, but it might well be that we would want to be very careful about what kind of sanction we employ after it. I mean, certainly if it's anything to do with making derogatory comments about an employee or something like that, there is a very good chance that that might result in a summary gross misconduct dismissal. So always good to seek some advice on that. The next slide I'm going to cover is whistleblowing, very much just because I want to have it on your radar rather than I really think it's something you're going to have to face. But we do hear, and probably any employment tribunal matter that makes the news, often or not, people talk about whistleblowing. And as I've said here, it's clearly written in the law that there are set laws that protect whistleblowers from their employers, subjecting them to a detriment or dismissing them because they've spoken up. So I suppose I'm working on the basis that maybe we all know what whistleblowing is, but you tend to find whistleblowing is much more common in organisations such as, for example, the National Health Service, where, for instance, a nurse might whistleblow on something if, for instance, there was a procedure being followed by colleagues that affected the health and care of patients. So I'm trying to think of an example. An example might well be, for instance, that, say, a nurse whistle blew on colleagues who were meant to take patients 3 times an hour who were on medication, but in fact they only did it twice an hour. I mean, that's obviously potentially quite serious implications for a patient, and it might well be that if a nurse or a doctor or something who was in that situation saw that they were falling short of what the standard practice was, they might bring what's called a whistleblowing claim. Again, as I say, it's probably not something I'm hugely expecting for there to be in congregations, but it might be something that I suppose is maybe slightly more of an issue safeguarding wise if there are irregularities or something like that. But I thought just when I was preparing the slides, it's worth having it on your radar because whistleblowing is it is a sort of trendy employment law topic at the moment, albeit the actual grounds of having a successful whistleblowing claim are fairly stringent. But I mean, if you ever do think there is an issue where someone is whistleblowing or anything like that, or the word is ever used, I would probably come and speak to me about it ASAP, just so that you can get some guidance on it. I mean, sometimes I think there's, I mean, there is obviously a difference, I think, between sort of, I mean, obviously letting your employer know about something and actual whistleblowing. I mean, often or not, whistleblowing is something that, as I say in the example I gave about the nurses, you know, not maybe following strict NHS procedure. I mean, it can have often something you whistleblow on might have significant implications for the organisation or the charity, rather than, for instance, you know, it's something small where you know, if an employee, you know, for example, if someone whistleblowing a colleague who maybe leaves work 10 minutes early every day, chances are that's not really significantly whistleblowing. It tends to have to be something that is obviously going to have a detriment on someone involved. And I think we're on to the last of our slides, both covering redundancies. We've obviously spoken about a bit about that already, but this is something that we do have to look at, not infrequently now with congregations as redundancies. And as I've said here, although all businesses hope they will always be able to avoid redundancies, they're an unfortunate fact of business life. I think one of the things that sometimes confuses people about a redundancy is, you know, what actually is a redundancy? And a redundancy effectively is where, owing to the lack of work, someone's role ceases to exist. So hypothetically, for instance, an example of that might well be if the Church of Scotland rather than ask me to deal with employment law and litigation or safeguarding work, which is what I deal with, outsource that work to a third-party solicitor. Arguably, I would have nothing to do because I don't buy and sell manses. So someone might say, well, my role is redundant. But effectively, for the role to be redundant, it means there's no longer a need for the person to do the work they're doing. So a much more straightforward example, I suppose, might be, for instance, if you have just gone through a union, you've got a cleaner who cleaned a church building, and as part of the union, the building she cleaned was meant to be sold. Well, obviously, if there's no building for her to clean, she can't clean the building. So there's a possibility her role might be redundant. One of the most important things when you're dealing with a redundancy in law is that whilst it's a bit of an elephant in the room, the redundancy itself, as an employer, you have to show that you've taken steps to avoid a redundancy situation or to try and avoid the redundancy situation happening. So, for instance, if you were going to make your church cleaner redundant, you would be duty bound to try and see if there was alternative work that the cleaner could do so that you wouldn't need to be made redundant. It is very difficult in congregational settings for redundancies to be avoided, which is why I think many people think it's a bit of an inconvenience for them in the role you guys are in to have to look for alternative work. I mean, for example, if say for example the church central services where I work at the church didn't say, gave all the employment law work to another law firm to deal with, and I didn't need to do it. One way that I suppose I could avoid redundancy might be is I could be, rather than work as a solicitor for the church, I could go into their human resources department, because obviously the skills I've got are transferable and I could use those. So that's a way my redundancy arguably could be avoided. But it's very difficult in church congregational settings on a practical level to see how that could happen, because obviously you've got your main roles of sort of cleaner, organist, maybe sort of caretaker, church manager or something like that. I mean, it'd be very difficult. I mean, you know, you couldn't have a scenario where you could say to the church cleaner, well, sorry, your cleaning role's redundant, but we are looking for an organist, so do you want to do that? Because she maybe I suppose it may well be the cleaner can play the organ, but chances are it's not a natural transition of the skills. So, you know, there's not necessarily a fit. Whereas, obviously, for instance, if you are working in Sainsbury's and you stack milk and cheese in shelves, and you know Sainsbury's stops selling milk and cheese, you could probably stack vegetables and fruit as an alternative. So it's that type of thing. You have a duty to try and find an alternative role. But I think certainly in congregational settings, if you guys are ever likely facing a redundancy, the chances are, whilst you have to go through the steps to avoid the redundancy, it's going to be very unlikely you're going to be able to do it, because the roles in congregations tend to be very specific with what you've got. Voluntary redundancy isn't something that we tend to come across so much in congregational settings. I mean, it can be mooted if you're going into a union. You know, certainly one congregation I was speaking to in the Central Belt a while back. I think the way it worked is something. I think when they went into the union, they would have had something like 6 or 7 organists. It was a huge amount, and I think the reason for that was they all kind of dipped in every so often to do a little bit of playing. There was not really one sort of set organist, so there were a lot of people kind of doing bits and pieces. And in that circumstance, I think there was one person who was like, just because they played at that church for years, didn't really want to go into the union, and thought they would call it a day. And I think in that particular circumstance, we discussed a voluntary redundancy, but it's not something we're going to come across, I think, hugely in day-to-day life in congregations. And the last slide, please, Natasha, just a little bit more about redundancy. Obviously, if you are made redundant, you've been with your employer for 2 years, you are entitled to a statutory redundancy payment. If you're ever at that stage, I've got style letters and will help you calculate the redundancy. I've just given some advice actually to a congregation today about calculating a statutory redundancy payment for one of their administrators. You obviously can calculate yourself, but if you don't want to, I'm quite happy to do it for you and let you know what the compensation payment is. Similarly to everything employment, you'll probably notice a bit of a running theme here is appeals. So in any kind of process involving employment law that you have, whether it's disciplinary capability, whether you make someone redundant, they should be given the opportunity to appeal the decision. Doesn't necessarily happen on a huge number of occasions. I think most people are slightly accepting of the decision, but others will appeal the decision, so they should have the opportunity to do that if need be. And obviously, in any appeal you're dealing with, it goes without saying, and obviously I would give you strict advice on it, that the people who are dealing with the appeal should be separate to people who deal with the initial decision or discussion. So, for example, if Joe Bloggs and Sue Smith make somebody redundant or discipline them, and that person who has been dismissed or made redundant appeals the decision, clearly it should not be Joe Bloggs and Sue Smith that hear the appeal, because the appeal would be regarded as bias. So it would be a matter of getting new people in to have an independent approach to that. And I think I've already kind of touched on alternative employment in the setting of redundancies. Again, in any redundancy situation, whether it's going to be a small congregational setting or somewhere like Sainsbury's or the Royal Bank of Scotland or some massive organisation, you're duty bound to have discussions with employees about alternative employment, although the reality is in a congregational setting it's unlikely to take place, but for records you do have to have a note of it anyway. So that's me on that. Quite a lot of topics covered in that, but issues that you may well not face on occasion. As per usual, happy to take any questions now that anyone has. Alternatively, Natasha is very kindly going to put all these slides together, so you've got a lot handbook of everything we've got. But obviously, come to me if there are any issues. I'm always more than happy to help out. Just give any general advice, or obviously if it's a larger issue you want styles or anything, always happy to guide. So.
Yes, Sue. Susan, sorry, my apologies.
Can I ask, we have the standard Church of Scotland contracts that you mentioned, with grievance procedures and disciplinary procedures and all these aspects.
Yeah.
Now, we haven't got staff handbooks, and we're hoping to produce those. To us, it seemed to begin with that it'd be useful to take some of these procedures out the contracts, put them in the handbook, and just refer to the handbook in the contract. Is that, you surely don't need to have it in both places?
No. I think you would want, and I would give you, if you want to go down that route, Susan, that's perfectly sensible. I think, in fact, actually, that is what my own contract with the Central Services of the Church has. But I think what you want to have, and I would obviously assist you with that, with the contract, you would want something in the contract, the exact wording, I'm slightly ad-libbing here, but you would want something along the lines of, by signing this contract, you're deemed to have read and accepted the terms and conditions of the staff handbook, with the policies in it. So obviously, the contract that you sign obviously has like the disciplinary and the grievance procedure in it. So by signing your contract with the employer, you're deemed to have read them. So I think if absolutely you can remove those schedules from the contract. I mean, it's one of those things where, as I was kind of indicating through this, I mean, there are so many policies you can have. I mean, I included just examples. I mean, I don't expect you all to come off this call and start drafting your drug and drinks policies. Really not going to be a huge problem for you, but just something to cover, because obviously, it can be a sensitive issue, and I mean, it does happen, unfortunately, sometimes, especially if people sometimes do use alcohol as as a coping mechanism for difficult times. And you do have situations where, and I have actually, in my own working life, had to deal with situations where people were drinking at work, and it's unpleasant, because they're not, they're clearly going through a difficult time and everything else, but at the same time you need to be aware of them. But I don't think in a general sense you need them. But no, absolutely, Susan, yes, completely. I think that is absolutely right. But it wouldn't be a case of simply chopping out Schedule 2 and Schedule 3 of your contracts. What I would want to do for your contracts is insert a new additional clause into the body of the contract that says something. I mean, I would obviously give you more eloquent wording, just depending on what it is, but something like, by signing this contract, I'm deemed to have read and accepted the terms of the employee handbook, which will be given to me on my first day of employment, or something along those lines, just so you've kind of covered it. Because what you don't really want to happen, I mean, obviously, you do have situations occasionally, but you don't, I suppose the ones we include in our templates are the most kind of classic ones you'll face, like disciplinary, I mean, obviously, you don't really need to have something about the adoption leave-in, but disciplinaries and grievances are probably two of the more classic employee issues. And what you can, employees do, and I mean, obviously, as a solicitor, I'm far more fussier about reading stuff before I sign it. But I mean, I definitely have friends who I could put a piece of paper in front of them and they would just sign whatever people do. And I mean, obviously the reality isn't by signing something that it does say that you've read it. So people who say, "Oh, I didn't know that was the disciplinary policy," or "I didn't know I could be disciplined for that." The reality is, if it's in their contract, you'd be like, "Well, you signed this contract." And that's what it says the disciplinary policy is. It says that if you do this or you don't do that, you might be subject to disciplinary. So it's just important to make sure there's something that kind of covers the fact the employee has read this stuff, because they will sometimes, if they're difficult, they might plead ignorance, and obviously that just kind of covers you off. But no, absolutely, I think there was discussion about the schedules 2 and 3 part when we looked at these contracts, whenever it was we looked at them, but we just decided to keep them in because obviously some congregations have only got one employee and they're not going to maybe want to draft handbooks or have too many policies in place. So I think the powers that be just decided to keep them in. But no, absolutely, the schedules are there and referred to, but they're not gospel, so they can come out.
I think if we issued a staff handbook, we'd need to make time to go through it with each staff member or include it in an induction process.
Yes,
it was
exactly.
just to save any wee changes, then having to change the whole contract.
Yeah, I mean, effectively, it's not going to be a huge paper exercise for you, Susan. If you do, it would simply involve the addition of this new clause in to the kind of body of the contract, saying who your employer was, what their name is, and removing schedules 2 and 3 from the back. I mean, it's not a huge redrafting exercise. So no, if you want to do that, let me know and I can help you do that. That by all accounts, probably the harder job is for you in drafting the handbook rather than actually making the contractual changes. So, yeah, I can help you out with that.
We've got Mike next, please.
Yeah. Susan's kind of partly asked the question I was going to ask anyway. But in our congregation, we are trying to work out what policies to put on our website, for example. And there will be some policies that affect everybody, for example, like the health and safety policy.
Yeah.
And today you've been covering, I guess, ones that are specifically for employees.
Yes.
So it's kind of slightly different. But is there, in terms of staff handbook, would you have to put a general policy like the health and safety policy into staff handbook?
I think health and safety is one of those ones that could probably go on your website, Mike, and be helpful for employees, because I mean, health and safety, I think the health and safety one being on the website is obviously you'll have visitors to the church who are not employees. So, help and the health and safety policy is obviously going to affect anyone entering the building. So, I mean, for instance, the health and safety policy would affect me if I walked into your church, because obviously if I slip on your wet floor, or whatever, the duty applies the same to, the duty would apply to the postman who's coming in, who slips on the floor, about filling in the accident book, in the same way it would apply to the organist who's actually your employee. So I think there is merit in maybe having a sort of much more widely available, highlighted health and safety policy, whereas clearly, disciplinary, using the postman example as an analogy, you're not going to obviously put the postman on a disciplinary because he's not your employee. So some of those policies could obviously be sort of less readily around. But having health and safety guidance, especially at this time of year. So no, absolutely. But I think, Mike, I would have thought probably for the purposes of your website, health and safety would be the only one you would probably really need to kind of circulate at large. Whereas the other ones, if you had, you may well be familiar with this term that we sort of have as like, I assume you probably don't, but if you had a kind of intranet, which is this type of thing that only staff members access, you could put the policies on that. But I think otherwise, so long as a copy is accessible, it might well be if you've got an office and you keep a sort of a ring bind folder with the policies in it, that might be better. I certainly don't expect people to be going on and making intranet pages and stuff. Obviously, I have the benefit of working in central services at 121. We have a staff intranet and I can access policies on that. But, that probably goes far and beyond, I think, what would be expected of you guys doing what you're doing.
Okay. In terms of the staff handbook, a lot of congregations will have employees who have been there a number of years. So another way of approaching it might be to bring that kind of thing into for new employees, rather than have to go back and rework contracts for a number of existing employees?
I think that probably could be the case. I think the important thing is obviously just with the usual things with employment, Mike. I mean, it's just make sure everyone's kind of treated the same. You know,
Okay.
I mean, it's the main thing. So, for instance, there's not more onerous obligation. I mean, I suppose for things like health and safety, it's very difficult to see differences, but I think, you know, it's obviously more from the sort of employee rights perspective, that, you know, yes, some employees will have been with you for ages, and it may well be that, you know, I mean, clearly you're entitled to revamp contracts and do things. And I mean, obviously the purpose of revamping things is to make them better. But I mean, I suppose I suppose the most important thing, and just to be at the forefront of your mind, would be, you know, just taking something like sickness policy, for instance, as an example. You wouldn't, you know, there may well be entrenched within your congregation a policy for sickness and what you do. I suppose the only thing that the only thing to bear in mind is if you're then changing it for kind of employees who are going to come in the future, is that, you know, their terms and conditions are not worse than the people you've got, or I suppose arguably, and perhaps even worse for your long-termers, that they're better. You know, you wouldn't want, I mean, you know, it wouldn't be fair someone who's been employed with you for 20 years only gets 3 months of full pay, sick pay, whereas, you know, if you just by some chance join after the 1st of January 2026, you get 6 months. So
Yeah.
it's just ensuring that that everyone's treated equally is the main thing. But yes, I mean, obviously, you know, if you've had someone employed with you for many, many years, I mean, you can issue them with a new contract if you desperately want, but I mean, it might just be more work than it's not. But so long as everyone's kind of given the same employee benefits, and that's the important consideration really with that.
Okay, thank you.